Okay, good.
Okay. Good evening, everyone. This is a regularly scheduled meeting of the Montclair Township Planning Board. Excuse me. In accordance with the Open Public Meeting Act, adequate notice of this meeting has been provided by posting a copy of the notice on the first floor of the municipal building and by sending a copy to the newspaper designated by the township for notices. Electronic notice of the meeting has also been provided by posting a copy of the meeting notice along with access instructions on the township website and also on the main access door of the municipal building. This meeting is being broadcast live on Channel 34 and streamed live and will be available on YouTube. This meeting is a quasi-judicial proceeding, meaning that the board has powers and procedures resembling a court of law, and that we are obligated to objectively determine facts and draw conclusions from them in order to provide the basis for official action. Any questions or comments must be limited to the issues that the board may legally consider in reaching a decision, and decorum appropriate for a judicial hearing should be maintained at all times. Members of the public in attendance are automatically placed on mute until such time as the meeting is open for questions or comments from the public. At that time, the public will be unmuted and they may provide their verbal questions or comments as appropriate. In the event there is a problem with doing this over the audio portion of the broadcast, they can also direct questions or comments to Ms. Talley, Board Secretary, by the chat or question or answer function on the platform, or there's a last resort by emailing her at jtalley@montclairnjusa.org. Again, jtalley, Talley, at montclairnjusa.org. First thing on our agenda for this evening, as always, is our roll call, and I am here.
Okay. By the way, I muted everybody to preserve the audio quality. So if you could just unmute yourself and tell me when I call your name. Vice Chair Prodoc?
I'm here.
Mr. Cook?
Here.
Mr. Graham?
Here.
Mr. Inwali?
Here.
Ms. Lockman?
Here.
Councillor Schlager is excused. Mayor Spiller is excused. Ms. Willis?
Here.
Mr. Gilmer?
Here.
Mr. Jacobson?
Here.
And we have Mr. Neese and Mr. Chandler here as well. Okay. And I believe we have Mr. Giosa as well. So the next item on our agenda is the minutes from the May 17th meeting. I didn't get any changes or amendments to the minutes. Are there any further changes? Or can I get a motion to approve the minutes? Second?
Second.
All in favor?
Aye. Aye.
Opposed? Abstentions?
Abstain.
I think Mr. Gilmer is going to abstain. Okay.
Yep.
All right. That brings us to the resolution for application 2705 Montclair Acquisition Partners. And I'll let Mr. Neese take the lead on discussion of this resolution.
Thanks, Janice. This afternoon, I sent an email out to the board members concerning the status of the discussions that I had had with Mr. Troutner, who is, to my knowledge, is here among us. There were some concerns that were expressed by some board members, which I asked Mr. Troutner about. And there was one issue that was raised by Mr. Giosa that I heard back from Mr. Troutner on today as well. Effectively, The first concern expressed by the board members related to the fire official who was going to be inspecting the garage. And the suggestion was that if the fire code official determined that there was to be a reduction in parking, that the applicant ought to come back before the board for amended site plan approval if that reduction were merited a change in the way the applicant did business, meaning the way the cars were parked. The second issue that I picked up referred to the acceptance or not by the applicant of Mr. Giosa's report, or at least his capacity calculations. And both of those items, the fire code official and the calculations by Mr. Giosa, were not acceptable to the applicant. There was another concern expressed by another board member concerning the inclusion or not of a reference to the litigation that was going on between Elcor and the original purveyor of the lift and slide mechanism. I decided not to comment about that, but instead would leave it to the board to discuss whether or not they thought it appropriate to include that reference. Those are what I picked up. I've spoken about, not the last one, but I've spoken about the other two matters with Mr. Troutner. And as I've indicated, he gave me his feedback and I forwarded that to the board earlier. If the board has questions about the applicant's rejection of those items, Mr. Troutner has indicated that he will be happy to, I don't know how happy he'll be, but he will certainly address them if the board wants him to.
Well, it was my recollection that the applicant did agree with Mr. Giosa's capacity analysis. And at one point, since there were questions on Ms. Bryhoff's report as to the underlying information and the basis that, you know, the parking counts that it relied upon, that at one point the applicant had said, you know, we're accepting Mr. Giosa's number. And, you know, I think subsequent testimony said that they had, you know, achieved a parking capacity that would meet that demand that was projected by Mr. Giosa. And that's what I recall from the testimony. And I haven't gone back to review it, but I think that's an important point if my recollection is accurate.
Yeah, no, I think your recollection is pretty good there, Mr. Broddock, except that there is a nuanced response to that from the applicant. And with the board's permission, I think I'm not going to represent the applicant. So if you want the applicant to respond to that, I would suggest and recommend that Mr. Troutner do so.
I'm happy to have Mr. Troutner here.
Okay, Mr. Troutner, I've unmuted you, so you should be able to be heard. Tom? All right, let me see what I can do. Okay, Tom, you're unmuted. I'm not sure what's going on. You can use the chat function, Tom, but I've showed that on here that I've unmuted you. And I don't know if your audio is turned on. Oh, Tom, okay, your audio seems on. Can you hear me? I can't hear you. Nothing's happening on your end. Yeah, I don't know why your audio is not working, Tom. You're unmuted. We just can't hear you. He's going to try and log out and log back in to see if he can get his audio to work. So meanwhile, I've pulled up the resolution and I'm sharing it with everybody. If there's a certain page that you want me to go to for discussion.
Well, I assume everyone has seen the revisions that were proposed. As always, I'm very happy and thankful that the board reviews my resolutions as carefully as it does. There's nothing that jumped out at me when I read through them, and so I guess I'm okay with the final version, but we do need to hear from Mr. Troutner.
Okay.
So, Arthur, I guess, I had the question that you can address that Tom doesn't need to address about why we're including a footnote of a case that we really never talked about. It was just kind of referenced obliquely at the hearing, but you have it as a footnote here. And in my mind, if someone were reading this resolution years from now, they would think that that case might have been something that we discussed in detail, and we didn't. So I would object to putting that here, even as a reference in a footnote.
Yeah, and I understand that, Carmel. I put it in only for the sake of completeness, so that if anyone in the future wanted to go and research the case, at least the case citation, the docket number of the case, was there. Clearly, the board has no involvement in the litigation, and I agree. And in actuality, the video and of the board's hearing, there was no discussion of the case because the LCOR representative believed that he couldn't talk about it. So it was really, from my vantage point, it was really more for completeness. I'm not wedded to the idea at all, Carmel. If the board doesn't want the reference to it, I'm okay with that.
I mean, I don't know how other people feel about it, but I feel like, our resolutions, they go, line by line, meeting by meeting about what we talked about, what our ideas were about the issues that we talked about. And then there's this case reference, and I agree, it's a reference to an active case, but as I said, we didn't even talk about that. So I don't know that it should be there, but I'm not forcing the issue, but I just think that it shouldn't be there. And I understand your point, Arthur, but.
Mr. Troutner, I've unmuted you again. Oh, all right, maybe this will work. All right, Tom, I made you a panelist. You have to turn your audio on and you should be able to speak. Okay. All right, Tom, I think we can hear you now.
All right. So sorry. For some reason, I always have this problem with Cisco WebEx. My apologies, everyone. So when last we were, I was listening to Mr. Neese's opening and listening to Vice Chair Brodock. And I guess as to the issue of the acceptance of the parking demand analysis, I'm not sure that this is a major issue, but the nuance, I guess I would say, is I would characterize based on my recollection that the applicant submitted the analysis of its own parking expert. Mr. Giosa, as the board's expert, submitted comments and his own sort of thoughts and analysis regarding an opinion that specifically parking demand in the future may increase or be greater than what the applicant's expert had said. And the applicant kind of thereafter took the position that if the board is accepting Mr. Gios's analysis over the applicant's expert's analysis, the applicant's parking plan nonetheless would still be able to accommodate the projected demand as identified by Mr. Giosa. So that's the nuance, that the applicant never actually retracted or abandoned its expert's analysis or position, but rather just that the applicant said, okay, if you're accepting Mr. Giosa's numbers, we still meet them. That being said, and this is the part where I don't want this to get lost in terms of it's a huge battle. The record and recordings of the hearings speak for themselves. So from my perspective, I don't know there's a need for us to really argue this point to the extent that somebody thinks I'm wrong about my recollection of what happened or the applicant's wrong about their recollection of what happened. I don't know that the statement needs to be in the resolution one way or the other, but just to be clear on the record, the applicant just doesn't agree that it accepted Mr. Giosa's parking analysis, wholesale. So that being said, with all due respect to Mr. Giosa, of course.
I don't think I would take a hard position either, but just since we're putting everything on the record, my recollection is that Ms. Bryhoff and perhaps Mr. Sokich was going to provide some of the underlying information and a discussion of the underlying data that we called into question at one point, and I don't think that really happened. And as far as I think when I raised that question in one of the hearings, I think the statement was made, no, we're accepting Mr. Giosa's demand analysis. So I'm not going to make a big deal out of it here, but since we're putting things on record. And then in terms of the other one about the fire marshal, we can strike my edits on that.
Arthur, does that, are we good then, or?
Yes, as I've already explained to the board, the language that was proffered by Mr. Giosa late this afternoon, you've agreed
Yes.
that it will be included in the resolution. So if my tally is correct, forgive me, Janice, but if my tally is correct, the only issue that I can see right now relates to Carmel's concern about the inclusion or not of the citation to the federal court litigation in the resolution. So I guess, I'm not wedded one way or the other to it, as I've said. So it's really up to the board. It's your resolution, and obviously I will do whatever it is that you want to do in this regard.
Arthur, could we simply make note that the board didn't discuss the case and is not a party to that litigation?
Certainly.
Why don't we just note that in the footnote, and it's you still have your completeness of referencing the case and noting that the board didn't discuss it and wasn't part of it. Carmel, would you
Yes.
agree with that solution?
I would agree with that. Yeah. Yeah.
That's not a problem at all. Easy enough to do. Any other concerns that the board has with the resolution?
Were the other changes accepted? I mean, I think I made some edits.
So did everyone see Carmel's edits?
I'm okay with them.
There is one condition, paragraph number 8. The last 2 sentences. Tom, can you see that resolution? And
Can you
that's,
make that bigger, Janice?
Yeah, I was going to ask if that could be blown up. I see it, but I can't really read it.
Thank you. I thought it was just me getting old.
I think there's also a button on the left-hand side of your screen that'll allow you to zoom in as well.
Yeah, I think that was my edit there. If such
It was.
records show, yeah. I mean, so we say that they have to maintain all these records for 7 years, but what if they're in violation? This is my point. What if they're in violation of the conditions that we established? There should be some consequences. So that's, I'm trying to say, if the records show that this resolution is not met, then they're required to correct the deviation at a minimum.
so I agree with you on that, Carmel, but the remedy available is first, I'm sure that there's going to be some interaction between the zoning officer and the applicant if there is some problem. And then, as both Mr. Troutner and I discussed, and we discussed with the board, if there is no remedy, if the problem persists, then the township has the right to summons the applicant, dragging the applicant into municipal court where the matter will be heard. So there is a response, one that has some teeth to it. So I'll just say that and leave it at that.
And Arthur, if I might, there may be a way to sort of capture this within Mr. Giosa's suggested addition, because I think Mr. Giosa's paragraph that we discussed this afternoon that talks about should it be determined that the summary reports on-site observations and/or parking counts indicate that capacity issues have arisen, and then it goes on to talk about working with township officials to identify and propose and implement remedial solutions. I think that covers a lot of this. And then if need be, I suppose it could be added that, in terms of working with appropriate township officials, that the applicant could be requested to provide, additional detailed records. I'm just trying to, I don't know if it makes more sense to put it there than, or rather than, to have duplicative, paragraphs, but.
I would agree with you that Mr. Giosa's language does cover my point, and we just got it today, so I'm happy to strike the addition that I made.
And by that, you mean the last sentence?
Yes, the last sentence. If such records show that the conditions, starting there.
Okay. But obviously, the board secretary, acting for, I guess, on behalf of the zoning officer, Janice, can request detailed records. Janice? Did we lose our host?
No, I'm here. Sorry. Yeah, we work very closely together, the zoning officer and myself. So as long as we're both mentioned in there, he's actually the enforcement arm. So that's fine. I can make the request and then he can be the enforcement arm.
Okay.
Okay.
Let's see.
I think we're getting rid of this. Arthur, do you have any other changes that you think need to be discussed?
I don't see any. Again, I very much appreciate that members of the board review the resolution as carefully as you do.
Okay, so is there a motion to approve the resolution as amended?
So moved.
Second?
Second.
All in favor? Or do you want me to call a roll?
Call the roll, please.
Okay.
Janice, point of clarification.
I did read the resolution, but I believe that on these matters, I'm still required to abstain. Is that correct?
Yes,
Thank you.
okay. Vice Chair Brodock,
Yes.
Mr. Cook,
Yes.
Mr. Ian Wally.
I abstain. I recuse myself from this.
That's what I thought. Ms. Lockman,
Yes.
Ms. Willis,
Yes.
Chair Wynn,
Yes.
and Mr. Gilmer.
Yes.
Okay. I believe Mr. Jacobson abstains as well. He wasn't part of the.
Unhappily, yes. 'Cause I'm also ineligible.
Okay,
I thought about watching all of the videos to be able to, be able to participate, but life's too short.
that's right. Appreciate that.
I considered you a very smart guy when you came on the board, Jeff. You've only proved it.
Okay,
Thank you, everyone.
that brings us to our new application, which is application 2725, St. Teresa of Calcutta Parish at 712 Grove Street. This is a minor site plan to install a freestanding sign. And I believe we have Mr. Zimmerman here representing the applicant. So Mr. Zimmerman, I just made you a panelist. You get your audio going. I don't know if you have your audio turned on, Neil. Okay.
Work?
All right, Neil, now you got your audio working.
Okay, and you got my picture. Thank you.
Is there anybody else who else is associated with this application?
Peter Bakarich, our engineer, will be testifying as to the site plan, and I also have people to answer questions if need be.
Okay, I just made Mr. not Sitar, who was it? Peter Bakarich. I just made him a panelist so he can answer any questions regarding the site plan. Okay.
Thank you very much, Mr. Chairman, members of the board. Thank you for hearing this application. My name is Neil Zimmerman. I'm an attorney with the law firm of Waters, McPherson, McNeil in Secaucus, here tonight representing St. Teresa of Calcutta Parish, which owns the Immaculate Conception Cemetery. The parish proposes a freestanding sign at the intersection of Mount Hebron Road and Grove Street. The application complies with all municipal ordinances. No variances are needed. This is actually the third hearing on this application. We started off with the Historic Preservation Commission. The Historic Preservation Commission recommended the application with two notes. First, they recommended that the year that the cemetery was established be put on the sign, and that the planning board consider moving the sign a bit towards Mount Hebron in order to, quote, center it. The notation has been added, established 1895, and we will provide testimony as to the issue of the location. We then went to a development review committee hearing. An objector appeared at that proceeding, and so the DRC could not issue a decision. As I understand it, the DRC had two primary recommendations. First of all, they wanted us to eliminate the lighting, and second, they wanted us to add some landscaping. So we have submitted revised plans which do in fact eliminate the lighting and add some landscaping. That brings us to the board tonight. And as I indicated, we have just one witness. If the board's ready, I'll call the witness.
Please proceed.
Mr. Bakarich, Let's
Yeah.
see, I don't believe, have you turned your microphone? Oh, there we go. Okay.
Yeah, my video's not working, but the mic is.
Okay.
Peter, there's a button you hit show video that should do it.
Nothing's appearing there, but I'll try it as we go on.
Mr. Chairman, should we go, or you want to let Peter try and find the video button?
I think we need him in video.
Okay.
There's those three little dots down the bottom that also give you more options to connect your video. I don't know if that's helpful.
No, it's just giving a.
Yeah, Peter, I think the button is at the bottom of the screen.
One second. All right, there we go.
Ah,
See me now.
Ah,
Sorry for that.
Okay.
okay. Call Peter Backarich as a witness, please.
Mr. Backrich, can you hear me, sir?
Yes,
Would you please raise your right hand? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
yes.
Would you please state your full name and business affiliation for the record?
Peter Backridge, consultant to the parish. Professional engineer consulting for the parish.
You can put your hand down. Thank you.
Okay. Peter, would you give the board the benefit of your education, your experience, and your licenses?
Yes, I'm a licensed professional engineer in the state of New Jersey and New York. I've been practicing engineering since 2005 after graduating from Stevens Institute of Technology with a bachelor's and master's degrees.
Okay. And how long have you been licensed? I'm sorry.
In New Jersey since 2010.
Okay. And did you prepare the plans that are the subject of this application?
Yes,
I'd offer Mr. Backarich as an expert witness in the field of professional engineering, civil engineering.
You'll accept him.
Okay. Peter, would you?
Mr. Zimmerman, I'm sorry to interrupt.
Sure.
The plans that I have two plan sets, two sheets rather, and they appear to be prepared by Daniel Kopek Architectural Design. I'm not sure what the affiliation of Mr. Backrich is to that entity.
I work with Daniel Kopek. So as an architect incorporated in the state of New Jersey, he signed off on the plans.
But you actually prepared these two sheets that have been provided to the board?
Yes, and with his review as well.
Okay. Janice, do you want to mark the exhibits before we proceed, please?
Absolutely. Here we go. A1 is the application. A2 is the certification of taxes paid. A3 is the certification of publication. A4 is the affidavit of service. A5 is the site plan prepared by Daniel Kopek Architectural Design. Last date of revision, May 26, 2021. A6 is the HPC report dated April 15th, 2021. A7 is the DRC report dated May 28th, 2021. And A8 is the planning report dated May 28th, 2021.
Thank you. Mr. Zimmerman, sorry for the interruption.
No problem.
I'm going to interrupt again too. Sorry about that. Ms. Talley, did we get a copy of the DRC report?
Yes, it should have been it was attached to my report.
Gotcha.
So the last page, it's in there.
Okay, because I didn't have it as a separate file. I wanted to clarify. Okay, thank you.
Okay, Peter, would you explain the plans?
Sure. So basically, the church is looking to put a sign at the corner of Mount Hebron and Grove Street. And in doing so, we wanted to make sure we are complying with all the local ordinances. So we are pushing back the existing chain link fence, as you can see on the plans, approximately 20 feet off of the property line. That way it gives us enough of a setback for the sign to be a minimum of 6 feet off the property line. And where we located the sign was to be free of any obstructions that are currently at the curb line. There's an existing traffic signal pole, an existing street light. So we wanted the sign to be centered between those two features. And that way it's not centered along the fence line, but it's centered kind of between the obstructions that are along the roadway right now. The sign, as you can see from the image there, measures approximately 12 square feet within the zoning requirements and will be installed approximately 30 inches above grade within a concrete footing. The post will be set, and we will have some, as indicated in the plan, some landscaping that we will add in around the base of the sign, a little bit more elaborate than we had shown on the previous application to the DRC.
Okay, you've mentioned the landscaping. The DRC also had concern about lighting. Would you explain what the applicant did in response to that concern?
Sure. So we removed originally we had shown some solar powered ground mounted floodlights, I would say. There was a concern, extra illumination for the area, so we removed those from the drawings and from the plans. And there is enough ambient light in the area because the existing, the one circled in red right now where it says existing, right, the pole right by the existing catch basin, I believe is a street light as well. So we'll have enough ambient light in that area. So the solar powered lights were removed and not needed for this sign application right now. So those are the two changes that were brought up, was the landscaping and the lights, and we removed the lights and added some additional landscaping. We provided a potential plant list, just one availability at nurseries, and also we can plant all of them or mix and match.
Now I'm sorry, Peter, you go ahead.
No, that was it, Neil.
The HPC recommended considering moving the sign. Would you explain to the board your recommendation as to that?
Sure. So again, the sign as circled in blue on the screen is centered between the two obstructions along the curb line, with one being the existing traffic signal and one being existing utility pole / street light. We want to center it between there instead of locating it behind. If we centered it on the fence line that's angled, the chain link fence, I would say, it would be directly behind the existing traffic signal pole. So that's why we that's why we located it where we did along that fence line at the corner.
Okay. Now, in the DRC, there were some comments from individual DRC members that I'd like you to address. The first is the relocated chain link fence for the proposed sign, talking about replacing that with a, quote, more attractive fence. Would you tell the board the applicant's position as to that?
The applicant's position is to keep the chain link fence with the rest of the character of the cemetery. The entire cemetery's chain link fence going up Mount Hebron and also along Grove Street. So we wanted to, for consistency, wanted to keep the entire fence as the chain link fence. And this fence would be new, this portion of it, galvanized steel, so it would be newer in character than the rest of it, but it would still match with the rest of the context of the fencing around the property.
And there was also individual board members made a recommendation that the appearance of the sign be changed to a granite or brick sign. That's not our application, but would you tell the board why we think that this sign is appropriate?
We think the sign is appropriate for the area. It's typical to a church sign that, again, just kind of highlights the name of the cemetery for people in the area. And we didn't want to make anything too elaborate with larger footings, which would increase the cost and scope of the project, and also the size of the sign as well, with any kind of brick or granite that was, I think, brought up at the DRC meeting.
Mr. Chairman, that's all that we have.
Any questions from the board?
I've got one. Are those native plants that you've proposed?
Yes, I believe they are native. Yes, I believe they are native, and I don't know if they're shown on this plan here. I think they're below the what's on screen.
Mr. Broderick, we have a lot of flexibility as to the landscaping. We'd be glad to work with Janice Talley if the board feels that different species might be appropriate.
Correct. You could,
I know the Environmental Commission is trying to, have native plants kind of be the first choice. So if that's something that you can make happen, then I think that would be great.
Okay, definitely. Yes, we can look into that.
Thank you.
Thank you.
Well, I have one quick question. It doesn't seem like any of those plants would block the view to the left. I know there's a traffic light there, but if you're pulling down Mount Hebron, there's been some accidents there. If the plants block the view, even though there's a light, I don't think it would block the view, but I'm not sure if anyone here could comment on that.
Right. These plants are all, again, we don't want to block the sign either, or, obviously motorists are paramount in this area.
So they'd be low?
They'd be low. They're going to be,
Okay.
the sign is, 30 inches off the ground. These plants are going to be well below that. We're thinking about 24 inches at all.
Okay, thank you.
You're welcome.
Other questions from the board? All right, any questions from the public in
I
attendance?
have a question.
Okay, Carmel.
Yeah, it was raised by the objector at the DRC meeting as to why we need a sign there when that's not even the entrance to the graveyard. And clearly, everybody can see that that's a graveyard. One would think you might want to direct people to the entrance to the graveyard. It's more like a commercial advertisement, in my view, to have a sign there, because it does really nothing in terms of directional or directing people to the graveyard. So can you address why that's where you want your sign?
Yeah, I think I can take a shot at it if that the board, if that's okay with the board. This is a key intersection. Having the sign at this location allows travelers on both Mount Hebron and Grove Street to see the sign. It is a permitted accessory use, and we think this is an appropriate location.
Well, in my view, it serves no purpose because clearly people can see that that's a graveyard. There's no reason for a sign to be there. If you wanted to say where the entrance was, that would be a different story. But I mean, and you're not really doing much to beautify that corner. It's kind of a pretty drab corner. If you were telling me that you would put a nice wall behind the sign that would be attractive, if you were going to use a brick or granite or even wood in your signage rather than plastic laminate, that would be more attractive. But there's nothing in this sign that it's not needed in my view, and it's not attractive.
Well, I would respond that there's nothing in the ordinance that says that a freestanding sign needs to direct one to the entrance.
It merely just lets them know the name of the cemetery, does it not?
That's
It lets
correct.
them know that if you're driving down Grove Street and you're looking for that, this is it. This is Immaculate Conception Cemetery. I have no objection to a sign there.
I would have no objection to the sign if it did something to beautify the area in some way. But it really, in my view, doesn't. People like to look out on something and see something attractive. And that's not what this sign does. This sign is merely like a billboard.
It's not a particularly attractive corner at the moment. I think it is, it is obviously a matter of taste, but I do think the sign along with the additional landscaping I would disagree, Carmel. I think it would be an improvement compared to what's there now, given that the chain link fence that we currently have there really is I believe more unattractive than the proposal here. And I think this is relatively attractive with the shrubbery.
It would be nice if they put shrubbery in front of the chain link fence so that you're not looking at a chain link fence. Something like that.
See it no matter what. May I, if I may, one way that I've seen this handled is that they drop a little sign below the main sign that says entrance with an arrow to the right or to the left.
Well, entrances go both ways. You go left or right, you get in. You go down Grove or Mount Hebron, you can still get in.
Oh, that's true.
And if that's the case, I believe that it does do its job. If you can get in, I forgot about the Grove Street entrance. Then it does do its job that you know that you're at the correct cemetery. And as you continue down Grove or as you continue up Mount Hebron, you're going to hit an entrance to the cemetery.
Any other comments or questions from the board? Okay, what about the public? Anyone from the public have any questions of the witness on what he's testified about this evening?
I do. Yes, I do. My name is Frank Rabacki. Do I need to be sworn in?
No.
Okay, thank you. The first question is for the applicant. The St. Teresa is, as I understand it, one of 4 parishes reporting to the Archdiocese of Newark. Is that correct?
St. Teresa is one of 4 Roman Catholic parishes in the township of Montclair.
But it reports into the Archdiocese of Newark, correct? I mean, my understanding was that Mount Carmel and Immaculate were combined on the orders of the Archdiocese, so there's a reporting relationship, correct?
I wouldn't use the word reporting, but there is a supervision, certainly, of the parishes by the Cardinal Tobin.
Okay. So my question, I came in a little late. I didn't know if anybody on the planning board had recused themselves, or is everybody not finding any conflict? I guess that's a question to you, Mr. Neese.
And I'm sorry, Mr. Rabacki, I didn't hear you fully. Could you repeat your question?
I joined the meeting a little bit late, so I don't know if any of the members that were in attendance recused themselves from this application because of some business or personal relationship with the applicant.
I'm not aware of any recusals by any member of the board who is sitting here tonight.
Okay, thank you. And then to the applicant, to Mr. Zimmerman, my understanding is this cemetery is not a 501c13. It's being submitted under a 501c3. Is that correct?
I do not know.
Well, I mean, from the W-9 point of view, you filed a W-9, so it would have to be indicated on that, correct?
I don't know.
Okay. As far as the ordinance is concerned, this sign it was described by you and the engineer as being at the corner, but it was also described as being offset from the corner. As I understand the ordinance, and could you clarify your understanding, by having the sign offset the way it is right now, it is one sign for the allowed sign on the one frontage, Grove Street. It's a Grove Street frontage by the location. And the ordinance would therefore allow a second sign on the secondary frontage, which is Mount Hebron. Is that your understanding? That's the engineer.
Yes, I believe so, because we have located this on the sign based on the frontage of Grove.
I'm sorry, I didn't hear that. So this would meet the requirement for the Grove Street frontage?
I believe so.
Okay, thank you. And then the ordinance also allows a programming type of sign also in addition to the other two signs that would be allowed, one on each frontage plus a third sign for programming. Is that your understanding? That would be to Mr. Zimmerman.
Yeah, Mr. Chairman, I would object to that. Mr. Rubaki is talking about signs that are not part of this application.
No, I'm talking about the ordinance and what it allows and your understanding.
And I'm saying that the only thing that is in front of the board tonight is a freestanding sign, which is permitted by the ordinance.
Okay, fair enough. Thank you. I will reserve my other comments for the commentary part. I'm done.
Okay, any other members of the public wish to be heard? Okay. And
Well,
Councilor, that was
actually, I
your,
have one more question, John. Sorry, Chairwoman.
all right?
I had one other question of the applicant.
Go ahead,
You allow that?
proceed.
Mr. Zimmerman, it's been quite some time, as you pointed out, since the application was accepted and deemed complete. Are you waiving your right to have a, I don't know what you call it, summary approval? In other words, you have the right to just take this as an approval without a hearing here. Are you waiving that?
Yes.
Okay, thank you. That was my question. Thank you.
Okay, one last call. Anyone else wish to be heard? Okay, Mr. Zimmerman, that was your only witness, correct?
That's correct.
All right. Are there any members of the public, in addition to Mr. Rubaki, who wish to be heard on the application as a whole? And Mr. Rubaki, you can resume your comments if you, at this juncture.
Okay.
Let us know where you're going with this questioning.
I have no more questions. I just wanted to get, my questions only serve to get things on the record for the planning board to help them make a decision. My only comment is that I don't like, let me start again. This is not a permitted use in the residential zone. And while it's a generous interpretation of the ordinance to say that this cemetery, which probably has different filings with the IRS, but I really don't care, that this cemetery is a house of worship. I also have a little bit of an issue with the code itself, but anyway, this is a denominational church. In other words, certain people are allowed to be buried there and certain people are precluded from being buried there because that is the way the code is written. And in other cemeteries in the town, these same people can be buried there without discriminating. It's non-sectarian, but they're not allowed to have a sign. And I think that's a problem, especially this month, for a denominational church to be allowed a sign without variance, while a non-sectarian cemetery would have to pay for a variance, is a little bit of an issue that you guys should address. And lastly, as far as Mr. Graham's comment about not an attractive corner, yes, it's not an attractive corner. But I don't think Mr. Graham is probably aware of the zoning board application where a resident just recently last month went to great expense to remove her curb cut and driveway and move it over to the other side so that it would improve the corner. And now this same resident is going to have to face a rather ugly sign, a rather cheap sign, directly in front of their house. And that's the payback that this resident's going to get for doing the public good. You know, it's all legal, it's all good. You know, the church gets to do what the church wants to do. But don't feel good about this. Don't feel good about this approval whatsoever, because it's not a good one. Thank you very much.
Is there anyone else who wishes to be heard with reference to the application as a whole?
I would just like to clarify, Chairman, I was not aware of the issue with the driveway, and also my statement was simply in response to the statement that the sign and the flowers that will be proposed there are not attractive. My contention is simply that they are more attractive than what is currently in place there.
Janice, do we have any members of the public who are indicating they want to be heard? Janice, are you still with us? Are you on mute?
I'm sorry, I unmuted myself. We have two other members of the public. One is Mr. Cook, which I'll make you a panelist. I don't think we have, Ms. Sitar, you're part of the applicant, right?
Yes, she is.
Okay, so yeah, there's no more members of the public.
Okay, Mr. Zimmerman, then you can proceed. You're going to sum up, or you wish to submit.
Just very, very briefly, Mr. Chairman. In terms of Mr. Rubaki's comments about other cemeteries and what signs they could or couldn't put up, I think that that's speculation at best. There's no proofs of it in this case, and in any event, it's irrelevant to whether we comply with the ordinance. As to Ms. Lockman's comment about the landscaping, we'd certainly be amenable to a condition that the applicant would work with Ms. Talley as to the species and, for that matter, the extent of the landscaping. We want it to look nice. Other than that, we submit.
All right. That'll close the hearing. Members of the board, what say you?
I guess I should, Friday. Yeah, this is the entrance to Montclair. Okay, you're coming out of Clifton, you're entering Montclair. The graveyard is on the right if you're coming north. And this corner, people have to stop at a light. You're sitting there. I think, and I appreciate, Mr. Zimmerman, that the church will beautify this little corner. It needs it. It needs maybe some trees behind the chain link fence or some bushes or something to beautify it. If my fellow colleagues remember when we had the nail salon that was applying for new signage around Watchung Plaza, we went to great lengths to make them put in different kinds of shrubbery and beautify that little spot. And it really looks nice. That, at a minimum, I think is what the church should do, is really make a nice landscaping plan. And you agreed to do that, which is great. I'm very much against plastic signs, laminated signs. I much prefer a wooden sign, a brick sign, some kind of not man-made material. But that's not in our ordinance, unfortunately. But I wish that is something that you would have considered, is that just making it a pretty sign, especially because it's a graveyard. There's this sense of history and sense of longevity about having a graveyard. So I feel like the sign should represent that in some ways, which this sign does not, in my view. Yeah, and I just feel like it's really kind of unnecessary, but that's your choice, whether you want to have a sign there or not. But it doesn't really do much except advertise the fact that this is Immaculate Conception's graveyard. So I would not really be for this application, but I do appreciate that you're trying to do something with the landscaping. Thank you.
Anyone else? Tony, I see your mouth moving, but I don't hear anything.
Yeah, I just want to verify from Arthur, this is permitted, right? I mean, there was some question about whether this is a permitted sign, right? No variance is permitted. Okay. Thank you.
I was a little slow on the unmuting there, Tony.
Yes, it is a permanent sign. And yes, there are no variances.
And after a year of doing this, I'm still slow on the unmuting, so.
I want to kind of just echo Ms. Lockman. I don't love this. I would, under some circumstances, I would find a way to say no to it. I'm not going to lie down in front of a train, though, and I'm curious as to how my colleagues plan to vote. Were I the deciding vote, it would be a no. But I'm curious as a newbie to see what happens, because if I'm being persnickety, and if this is kind of something that we should not be drawing lines here, I would be guided by my more experienced colleagues' views on it. But I don't love this. I think Carmel is right that it's not really a great place for a commercial sign.
In response to the question, how other thinking, I think I'll just share my thoughts. That it's a sign that's approved by the Historic Preservation Commission. They said they supported the sign, and there's no variance required. So I think the sign is permitted. I don't know on what grounds we would refuse the sign, given that there is no variance and given that the Historic Preservation Commission has said that they approve of it. So, and that they have complied with the suggestions of the commission that the commission recommended that a date be put on it and that they move it westward, and they're willing to do those things. So I'm not sure on what basis the board would say no to it.
Which raises a question in my mind of why, what are we doing here? I mean, we got this at the DRC we got this not at the DRC. It was objected to, so it had to go to the full board. If this was not something that we really have a say in, then why have we spent 2 meetings, one in committee and one at the full board, talking about it? That's a question, and I would like an answer to that question. And because if we don't really have a say, then why do we have a say?
If I can answer that, Jeff, I think we have site plan standards. And while there are no variances associated with this, there's a minor site plan. And we can ask for information such as material, the signage. No, we don't require certain materials, but we can review it. We can review it in light of the property. They did make some changes that we requested, but absent any specific design standards, I think such as materials and such as, the context, which we don't have, I think the board would be hard pressed to deny it, but we have been able to give them some guidance in terms of its design and location.
And Jeff, also, if I can just make a real simple analogy here, if they wanted to take a piece of cardboard and nail it to a stick of wood and plop it in the ground, we could deny that, okay? But, if it's a reasonable sign, if it meets the requirements of the ordinance, this is a technical review, and there are as a new member, I understand you're not familiar with everything, but there are times when we do review things that the MLUL requires us to review, but we don't have the option to deny it as long as certain requirements are met. And our job is just to make sure that those basic minimum requirements are met. And in this case, that seems to be the case.
Got it. No, that's very helpful, and I think it's not only helpful to me. I think it's helpful to those members of the public that are listening in. So thank you very much, Mr. Chairman.
Sure.
And through this discussion, Jeff, I think Carmel was able to get some concessions on the landscaping as well, which I think are important for that corner. And, you know, I think that was good work on her part.
That's absolutely right. I agree 100%.
And we got the lighting removed too, so remember that.
That was yeoman work. No question about it.
And I'll take a 30,000-foot view and say that aesthetics are not really a standard on which the board can make a decision at all. It's not part of the MLUL, and unless we have design standards in our ordinance, we can't make decisions based on that either.
So with all of those things said, I'd like to make a motion that we approve the application, but subject to the conditions that we discussed with respect to lighting, also with respect to landscaping, that we would require that the applicant submit some additional landscaping that will go a little bit further with addressing the issue of the fence as it's exposed, and to add additional year-round plantings, native plantings, that will all with the design of improving the corner, and that the applicant work with the planning board committees with respect to resubmitting that plan and gaining approval. And Arthur, do we have any standard conditions that need to be included?
Yeah, we generally, because of the nature of this application, it will be the standard conditions about complying with the codes and inspection fees and the like.
Okay, so that's the application, rather that's the proposal and the motion with the conditions.
Okay, I guess I should call the roll.
Well, we need a second first.
I'm sorry.
Second.
Who seconded?
Second.
Okay. All right. Vice Chair Brona,
Yes.
Mr. Cook,
Yes.
Mr. Graham,
Yes.
Mr. Ian Wally,
Yes.
Ms. Lockman,
Yes.
Ms. Willis,
Yes.
Mr. Nguyen,
Yes.
Mr. Gilmer,
Yes.
and Mr. Jacobson.
Having been educated by my learned colleagues, yes.
Okay.
All right, Mr. Zimmerman, thank you.
Okay.
And that brings us to a couple of matters that we have to discuss, first of which being a council referral.
Yes, this is a very basic amendment to our fee ordinance. As you know, we changed the requirements for stormwater management plans. We now have what's called a minor application, which triggers stormwater review of applications that previously didn't require engineering review. We spoke to or worked with Mr. Chandler, the board engineer, to come up with a reasonable cost associated with that level of review, which was $250, per application. And so we recommend that we increase the cost for minor site plans and applications for variances that require variances for A, B, and C. Those are really applicable to 1 and 2 family homes, and one for expanded parking areas. We've added $250 to each of these escrow fees to cover the additional engineering review of those stormwater plans. So minor site plan would go from $750 to $1,000. The variance applications for 1 and 2 family homes would go from 250 to 500, and the cost for the expanded parking areas will go from 600 to 850 with this proposed ordinance. And I think if you saw my memo, I think this is consistent with the master plan, because obviously we amended the master plan to require applicants to provide these sign plans, these designs in their applications, and we need the fees for our board engineer to review them.
I got a question on that. Is this we instituted a very low square footage for green infrastructure of 250 square feet.
Right.
Okay, so now you got someone with a patio, they're putting a patio in. Normally they would put a patio in, no site plan. So now they've got to go in, they got to put this patio in, and they have to spend $1,000 to get 250 square feet of impervious surface reviewed, that they could probably dig a $50 little swale in their yard to solve it. I think this is a problem. I know of 2 people who got caught in this, and they said, I can't believe I have to go through this for a patio. And this is something that, we got caught up in because maybe we didn't think about this when we accepted this very low requirement on green. Not that I'm against green stormwater, but I think this is problematic.
They don't even have to pay this. This only applies for something that's defined as a minor site plan. That definition has not changed. It's just,
okay, well then I just asked if the 250 triggers it. So the 250 doesn't trigger.
What you're talking about, if they're putting in a patio, there's no additional fee for that. That gets reviewed by the township engineer. What we're talking about are, okay, 1 and 2 family applications.
No, because you said additional green infrastructure. I thought it was because we had that really low threshold.
It is,
they can go in. Okay.
But that's not changing. This is really just to pay for the additional engineering review of residential applications that would have been, they would have been before the board anyway. We just have to have an engineer review it, really for drainage, to make sure that they meet drainage requirements, basically grading and drainage, and green infrastructure. So it's not heavy duty. It's not meant to be heavy duty. It's just meant to ensure compliance with what our ordinance currently requires.
So for a residential home, when would a minor site plan be required?
It's not. It's only for, there's no site plan for a 1 or 2 family home. It's what we're talking about are variance applications. So if that patio required a variance, or it was, usually it's an addition to the house that requires a variance, and that addition is more than 250 square feet of impervious surface, that would trigger A, and it would increase this fee from $250 to $500, because they would already have to pay the $250 fee because they're going to the zoning board of adjustment. We're just adding another $250 because Peter, or whoever is the board engineer, will have to review that application as well.
So if they were putting in a 250 square foot patio that didn't need a variance, there'd be no fee.
There'd be no fee.
They'd go before the building department, and if they had to do a little bit of green infrastructure, our reviewing person would say, no, you need to do the green infrastructure to accommodate the 250. Okay.
That's handled by the township engineer. Yeah.
All right, thanks.
And are these aren't necessarily fees, right? These are just escrow deposits that are drawn upon by the professionals.
Right.
Okay.
There's no additional application fee. We're just increasing the escrow fee.
But to be perfectly honest, Janice, is there ever a time when we really give back some of that escrow?
Oh, I give them back all the time.
Do. Okay.
Yeah. Yep.
And isn't it true that when someone they have a chance to talk to your planning department or, what's his name, Richard Sharon?
Right.
About their plan before they go and apply for a variance. So there's given guidance there. Is that correct?
Yes, we give them guidance on zoning. We don't give them guidance necessarily on drainage, but we give them guidance on zoning.
Okay.
Suppose someone brought their own engineer And, instead of giving someone else a blank check to review it, you have your own engineer, you go in, and you present a plan which is compliant with the ordinance. Why is it, why do they have to pay that review? That should be on the town.
No.
Okay. So one engineer, so you don't believe an engineer.
In that case, in that case, our engineer would just, maybe they wouldn't spend it, he has $250. Basically, it's his reviewing that engineering plan to make sure it's consistent and saying, okay, this
Okay.
satisfies the requirement.
Even if the engineers, okay, got it. I mean, I just hate more fees and stuff. I just hate this friction to do stuff. But if it's, if these guys are going over budget, whatever, if you need it, that's fine. But, we're not presented with any evidence that the fees that we have right now are too low.
Right.
So you're just saying, let's just increase them by, 50%, which is pretty big.
Probably percentage-wise, but I don't think that these numbers are not large numbers. So.
Well, if you give someone a low budget, sometimes they'll do the work more cheaply. If they know they get 50% more money, it's spent.
Do you have any ideas how our fees compare with other towns nearby?
I think our fees are very, very reasonable. I have to say, in the past, our board expert fees have been very reasonable compared to what I've seen for some other towns. So I feel very comfortable with this. I don't think that this is an unreasonable, burdensome cost for some of these residential projects. Any other comments? So
How many times have these budgets? So if someone puts up 250 in escrow, so they don't get charged more than that. You say it's escrow, but they have to keep adding to the escrow if it costs more than the 250, let's say.
Absolutely. If there's
so there's really no limit now. If it costs more, they pay whatever.
Yeah.
So by doing this, okay.
Tony, let me be honest with you. The $250 that we charge right now for variance and appeals, that's the board attorney's fee. This is the zoning board of adjustment, and he basically cuts his cost. That's not every bill I get from the zoning board of attorney for residential applications. He adjusts it downward to meet that $250 cost, because we are very sensitive to the costs associated with residential.
Okay.
We said the same thing with trying to minimize the cost for reviewing residential drainage plans. And again, that's why we came up with just $250. It's a very simple review. And essentially we'll have to have some faith that they're not going to go beyond that, our board engineer, and that's certainly something that we'll evaluate as we continue to work with them. But the intent is that it will not exceed what we are collecting.
So this doesn't apply for any residential project?
No,
I'm confused.
The whole reason, no, these do. The item number 4 that you see on your screen, that applies to 1 and 2 family homes. Okay, especially number 6. That's really it's really not 1 and 2 family. Those are really whenever there's a multifamily project where they're expanding the parking area. So it's really just number 4. If they are, and it's only when they're asking for a variance. Okay, when they're doing a project, it's usually an addition, and they need a variance. You're going to, and it involves more than 250 square feet of area. Then they're going to have to do a drainage plan that's going to be reviewed by our engineer. Minor site plans are normally are not residential, which is item number 2. Those are actually commercial or multifamily projects. Any other comments? Questions? Is there any consent? I don't know if members of the board feel that this ordinance is consistent with the master plan?
When we're adjusting fees, it's a little hard to make that leap to master plan consistency. Since our master plan is not really dealing with fees.
Well, the problem is master
However,
plan establishes certain requirements.
right, and I do feel that the numbers that we're talking here are definitely reasonable numbers, and that for the types of projects that we're talking about and the cost of services these days, that I don't think that personally, I don't think that the numbers are objectionable. And what the council is looking for from us is a statement as to whether or not we support this as being in line with the master plan. And you know, there's a reason why we want independent evaluations of plans that are submitted by applicants, and it's for the protection of the township. You know, and I think that's how we make the leap between increasing fees, question of increasing fees, and whether or not something's in line with the master plan. So I would submit that we should support this. If there are comments, if there's something that you think is missing, we can always add opinions and questions. But this seems pretty straightforward. What does the rest of the board think?
And I would agree with that. And if we didn't feel comfortable saying consistent with, we could say not inconsistent with. That little twist on it, if that made people more comfortable.
You should have been a lawyer.
It's wording of the statute, by the way, not inconsistent.
I've learned from the fellow attorneys on the board.
Learned your lessons well. So I'm not hearing any objections to supporting it at this point.
I'm going to vote no because I will vote no because I think that if we saw a budget that said, look, this is how much we collected and this is how much it cost us, I'd say, okay, I get it. But it's really hard, and I really apologize. You know, these may be perfectly fine, but you know, if we said, you know, we've collected $100,000 and it costs us $150,000, we need to raise fees just like you're doing a budget. I would probably be okay with it. But now I'm going to vote no because I don't have the ability to see the evidence that we need it.
Well, if we don't collect it, we don't have enough money, and then we play catch up the whole time. That's the problem.
So we can add that as
whatever. I still feel the same way.
We can add a comment in our support that, you know, that we had board members who had reservations about this because they wanted to see more information about how often we fall short with our escrows, and that would have been helpful for us to in making the decision.
And I could say that if we don't do this, it'll be virtually every residential application that we only collect $250 right now, and that goes to the attorney. So we would have to go out and ask for more money almost every single time, literally every single time.
I just want to be clear that this is the zoning board of adjustment attorney that you're referring to now, Janice, right?
Yes.
Thank you.
Anyone have any objection to proceeding this way then?
Not with that stipulation, Chairman, that you just stated. No objection to that.
All right,
Okay,
Janice, you'll put the letter together?
I will.
All right, that brings us to our committee report. Discussion on the planning board bylaw.
And I don't know, are we ready to discuss that?
I can, I've got a, if you allow me to share the screen, I'll try my best to explain what I did. Want to give it a shot?
Okay, let's see.
And after 2 minutes, you can say, go away, it's no good, your explanation stinks.
Is that a prediction or an option?
That's probably a prediction.
Okay, just wanted to clarify that.
So I was gonna ask a question, like when we had the cemetery, I was gonna ask them, do you notice the dead people in Mount Hebron Cemetery for that? Or like, well, how does that work?
Seance.
You know, those people are dying to get in there, right?
Yeah, well, my relatives, I asked my relatives, I was up there the other day, they love the sign, it's awesome.
Tony, you have control.
Oh no, that's bad, okay. Okay, can you, let me get this out of here. Okay, so the colors, okay, so the yellow and the green and the blue, I just illustrated where I move stuff. So for example, this executive sessions, I moved over here. Okay, this blue, I moved over here, and this green, I moved over here. The gray I just deleted, I'll explain that later. And the red underline is the new stuff that I added. So I thought that the first thing that we should do is talk about the MLUL and keep that in open meetings and the the Public Open Meetings Act, and just give a little prelude saying that, you know, it's sunshine law related and so forth. And you talk about all the stuff relating to open meetings. And then you create a new section, which is 13-11, and you talk about communication specifically. And that's when you can talk and when you can't talk, and be really, really clear about when you can talk and when you can't. So that's the main changes. The deletions that I made, this talks about, you know, that all citizens have the right of free speech. It's like, I know that, do we really need to include that, you know, in here, if you want to keep it in there? But I think that the fact that there's a proliferation of technology, we all know that. I think if we're worried about technology being a form of communications that's not captured in communications, over here, we should put it in the definition. You know, it's verbal, it's electronic or whatever, and that way you define communications and you get rid of this because it really does nothing. And then the other thing I would get rid of is this paragraph here, which talks about, you know, whatever we say is in a negative light, et cetera, et cetera. When I read this paragraph, it's kind of muddled and it doesn't really tell me a whole lot, except it sort of puts up this warning. So I thought, instead of doing that, just have it really clear. A, you can talk, and B, you can't, and make it like super, super clear on that. So that was kind of behind what I was thinking.
Tony, the only thing that I would say to the items that you want to remove, with respect to the first, well, with respect to both of them, I mean, these are recent additions into the bylaws, and they were put there because there were communications, there were things that were going on that we were concerned about, that we felt had the potential to cause problems, and we wanted to make sure that the board was cautious and cognizant of things. And as you say, well, maybe we need to redefine, have a good definition of what communication is.
Yeah, down over here.
I can agree with that.
Yeah.
But with respect to the warning language that you point to, you're absolutely right. It was meant to be a warning,
Okay.
because there are lots of different ways to say the same thing.
Mm-hmm.
And I think that we wanted to make sure that board members are specifically put on notice that even though as individuals we have the right of free speech, as a member of the board, we have to be circumspect with what we do because we are taking certain actions as, pursuant to law, and we want to make sure that those actions don't get misconstrued. We want to make sure that, our actions don't cast the town in a bad light, and that we, again, are just cautious about how we say things. And as opposed to, and we've had some instances where I think, I don't want to point to specific instances or specific things, but where people may have been careless or people may not have thought about the ramifications that would come from certain kinds of communications that we're now starting to use. I mean, 5 years ago, there was no TikTok, right? I think that's a form of communication now, and that's we have new things developing all the time. So we want people to understand that any medium that communicates a thought from A to B is a form of communication, even though it may not fit what in our mind is the traditional way of communicating or what we normally think about as communicating. A song could be.
That's great. I think to leave them in there is fine. I would just put them in communications and kind of work it in there. Maybe I just try to make this overly simple, but those gray areas I think probably should go down here someplace, and someone who's better at wordsmithing can kind of work it in there. I think that's okay.
Yeah, and I don't have a problem with that. I think it was put here at the beginning because it's kind of general. But as long as it stays in there, that idea, that we need to be careful what we say, how we say things, and who we say them to. I think that the purpose is served. So I don't have a problem with moving things around, as long as it doesn't change or limit the scope of the application of those things. And I see, I can see some of your logic with respect to wanting to organize it a little differently. So from my standpoint, I'm not against reorganizing it, but I think we need to replace the gray areas with some additional language if you're going to take those out.
Well, you can put them back in or whatever. I mean, someone can probably take. I'm not sure where this goes from here, but.
Well, what does the rest of the board think?
I would agree with.
Ready right now, by the way? I'm sorry.
I was gonna say, I would agree. I mean, I feel like those gray areas should stay in there. If they need to be wordsmithed, that's great. I agree with Tony's rearrangement to have a very clear communication section, and if those two gray paragraphs go into that, I'm totally fine with it.
Well, if you want, I can rearrange, make those changes, and then we'll meet again in 2 weeks, and we can reconsider this when we meet in 2 weeks. Because the only thing we have on the agenda at that meeting is the public hearing on the master plan amendment.
So Janice, if you could, do a little bit of wordsmithing over the next week and get it to us by next weekend so that we have a week to look at it and to play with it ourselves so that we can, if we need to, if we want to discuss it at the next meeting. That might be a good way to go. What does the rest of the board think?
So if it's all right with folks, Janice, I would offer myself, if you want to bounce some of those wordsmithing of the gray areas, there are other things that I say I don't know about. This one I do. So I'm happy to be a sounding board for the rearranging, because I agree with everything that everybody said. I agree with Tony's goals. I agree with the rearranging. I agree, more than agree. I insist that we need to keep the gray areas in there, because you guys haven't lived until you've been deposed on this stuff and had to search your personal emails and everything else for having to respond to Oprah requests for this stuff. So, let's by all means avoid that by sticking to what we're allowed to do. So if you want to shoot me, Janice, after you've rearranged, I can maybe give you some thoughts on the gray areas, and we can then circulate. I'll be around all week, and we can circulate it to the board, as John said, well in advance of the meeting. And I think we can do what Tony wants without committing errors.
Absolutely. I appreciate your offer of assistance.
Thank you, Jeff.
If you're going
Value somewhere.
before you do that,
Looks like a plan.
I would just ask that somebody take a look at subsection E of 13-10. To me, it's not clear. So, and we don't need to discuss it now. I just want the board to know that I don't find that terribly clear.
Okay. Fair enough.
I just have a question. Weren't there other comments on the bylaws that are not extracted here? I'm not sure, actually.
The only thing that I modified, I just included this section. I didn't know. I'm sorry if there are other changes. I didn't.
I will question. I thought I made some changes elsewhere, but I'm not positive. I'll go back and look at my file.
I think you did, Ms. Lockman, and I think I also made a couple of comments as well.
And I don't think we had any major issues with the other changes. It was just the section that Tony was focusing on, and we couldn't get a clear understanding the last time we discussed it of where he was going with it. So that's why we needed more time. But yeah, Janice, it should be what gets circulated should be the whole thing.
Okay. I got it.
Thank you.
All right.
All right. Sounds like a plan. Payment of bills.
Was there any
Mr.
other?
CFO.
The question though, was there other subcommittees that met? Other than DRC?
Not to my knowledge, no.
Revisions, but those are still underway.
Okay, thank you.
On the parking deck, Orange Road parking deck, we met a week ago. Yeah, anything from the chair we didn't make any decisions. They need to come back to us, so we'll update you when there's something. Yeah.
Yeah, because we got stuff at the last minute, and it was productive in terms of directing them what to do for the next meeting.
By the way, it's not the parking deck. This was 37.
That was right.
It's 37.
Sorry, yeah, right. 37 Orange Road, right. Yep.
Yeah.
Thank you.
Okay, can I have a motion to pay the bills?
I would move to approve the bills.
A second?
Second.
All in favor?
Aye.
Aye.
Opposed? Abstentions? Okay.
All right, everyone. It's 9:12 according to my clock, and that's a really good time. So thank you all for your cooperation and your participation, and we will see you here again next time.
Thank you all.
Thank you, everyone.
Have a good evening, everyone.
Good night, everyone.
Good night.